I think we will start. We do have some folks on the line, and in a second we'll do a little poll here to see who we've got with us today. But again, for those that have joined us and now, please settle in for the next hour or so, hour plus, and we will have some questions and answers and hopefully an in-depth interactive discussion. Even though I know this is a webinar and we can't see the attendees, we know that you're out there. So we are going to take this poll in just a second, but I wanted to let you know that we are welcoming today, and I'm going to just, maybe you could just put the poll down for a second, Jason, and then bring it back up in another second. Is that okay? Thanks. Great. So again, and we're all figuring this out, so thanks for your patience, but we are very, very pleased here at the League of Cities and Towns to have Jordan Cullimore, who's the lead attorney for the Office of the Property Rights Ombudsman, which I can never usually say, but I did today, as well as his colleague Marcy Jones, another attorney in the office that is doing training in land use, and so we greatly appreciate them here today. We also want to thank our sponsor, Union Pacific. Thank you very much for helping us out during this new adventure for us when we respond, recover, reimagine, the theme of our annual conference. Hopefully all of you had a chance this morning to log in. And again, we have some networking round tables this afternoon, which hopefully will be more participatory. And again, tomorrow, some more sessions, and Friday. If you haven't had a chance to look at the full agenda, please do. So now that much awaited poll that I was indicating, Jason, if you'd be so kind to pull that poll up, we're just going to get a sample of who's with us on the call. It looks like we have about, I don't know, 35 folks. And if you could just take a second and tell us, are you representing mayor, council member, city staff, attorney, planning commissioners, or do you just love to attend conferences? So just a sample of who we can have on, who we know we have on the line here, so we know how to answer. And I'm glad I'm not the attorney on this call. I'm the planner, so I can counteract all those attorney questions. So Jason, when you feel like you've got a good sampling of responses, let us know and we can post that so we know who we have on the line with us today. Any results, Jason? Or are you still thinking about it? There we go. Excellent. Thank you, Jason. So no mayors. All right. So we have the real brain trust, which is the city staff. That's great. So we'll get some answers to you guys. We have some state and county government, a few planning commissioners. So excellent. So we have a variety here, but mostly staff. So thank you so much for taking a minute. So now I'm going to turn it over to Marcy. Do you want to start with you, or Jordan? Who would like to start? And do you want to bring up your share screen while?
I'll start with saying a few things, Meg.
Excellent.
So thank you, number one, for having us on behalf of the League and APA. We're really excited to be here. We love to participate in conferences with both of these organizations, all of these organizations. I guess Wasatch Front Regional Council's here as well. And I see people on the line who I know, some who I don't. Thank you for attending, and we're excited to meet with you guys today. For those who have ever attended a Ask the Ombudsman session, you've probably done it, number one, with Brent Bateman, who is no longer with our office. But number two, we're excited to continue the tradition of the Ask the Ombudsman session and try to have a good conversation. For those who have ever seen our presentations or been in workshops with us, you probably know that we love interaction. We know that, you know, planning and zoning is inherently a local concern, and we want to know what's going on in your communities, and we want to be able to answer questions that you guys have that you're dealing with, working on. So we've talked with Meg, and we want you to ask a lot of questions. We have a few prepared questions that Marcy was able to gather from people in advance, and we'll try to kind of prime the pump with those. But please start pumping the questions into the chat box, because that's what we're really going to rely upon to try to provide some good, helpful content today. And so, yeah, with that, Marcy does have kind of also a brief presentation of what our office is and what we do, so that you know in what ways we can be helpful and when you can reach out to us. The short answer is always, but yeah, so we'll turn it to Marcy for that.
Thank you both. Yeah, glad to be here. As you all know, we're with the Office of the Property Rights Ombudsman. And just a little bit about us, we're a neutral, nonpartisan state agency. We're housed within the Department of Commerce. We, we help individuals and government agencies understand and comply with land use law and property rights law. We help resolve property disputes, not ones between two private property owners, but if you've got a private property owner and a government entity. We advocate fairness and balance, and wherever private property rights conflict with public needs, we're the folks to call. Our duties fall into three main buckets. We spend about 1/3 of our time on each one, I'd say. We answer land use questions from the public, and the public can mean anyone. We have attorneys call us, we have city attorneys call us, we have city staff, we have mayors, we have members of just property owners give us a call, tenants give us a call. We also mediate eminent domain disputes. And the third thing we do is we answer advisory opinions. And I'll just briefly kind of outline those for you so you know what sort of resource we could be for you. So the first thing we talk about is we answer a lot of questions. Last year, we answered 1,300 questions or calls from the public. That's up about 40% from the last year. There's lots of questions out there. These are sort of the typical questions we get. My neighbor's fence is on my property, what can we do? I get a version of this every single week, and the answer really, it depends. How long has the fence been there? Who put it there? What's the understanding of the fence? This was one I got recently. Can the city require me to pave the road in front of my home before issuing me a building permit? The answer is no. They can require it be paved before certificate of occupancy, but not before the building permit. It's according to state law. We frequently get calls from both sides of the issues. My neighbor wants to grow hemp, but I've heard it smells like skunk. What can I do? And I got the opposite call. I bought property to grow industrial hemp, but the Planning Commission just changed the zoning, so I can't. What are my options? And it really, I mean, it depends. With hemp, there's some state laws that apply, and it really, but also the local ordinance. So give us a call if you have those questions. We get a lot of, is the county required to maintain my road? Probably not, even if it's a county road. We get a lot of, my property is landlocked. What can I do? We'll discuss eminent domain in a little bit, but perhaps you can use eminent domain to gain access. If not, just talk to your neighbors, try and work it out. City mayor recently called and asked whether a specific non-conforming lot is legal. We can walk you through what the process is to make that determination. Council members recently have given me a call asking if they need to approve a conditional use. This one's a fairly common question. The answer is probably yes, if they can mitigate the concerns you had ahead of time, but we can walk you through that as well. We also can come do trainings on these sorts of questions. Another recent question, can dedicated open space have a slope of greater than 30%? What does the ordinance say? There's no state law about it. So those are sort of examples of typical questions. You're welcome to ask those sorts of questions today. But we also have a lot of our information is on our website. It's propertyrights.utah.gov, and you can see the big arrows pointing towards the find the law. If you click on that, our website actually has a lot of these topics on there and a lot of really good information. It's a good website. It's a little dated because we're a government agency, but it's also got really good information. So everything, we've got access rights, boundary disputes. We get a lot of calls on boundary disputes. Easements, exactions, impact fees, just compensation, land use appeals, LUDMA, non-conforming uses, public meetings, open public meetings, prescriptive road statute. We'll talk about that some today, I believe. That one we get lots of calls about. Takings, variances, vested rights, zoning estoppel. So a lot of that, it's all there on our website. So yeah, give us a call or look to our website. We're here to help. We're happy to help. The second thing we do is we answer advisory opinions. And advisory opinions are neutral, unbiased, written opinion applying the facts of a potential land use dispute or issue to the relevant law. So our office is created by state statute, and under state statute, we've been given authority to answer advisory opinions, or it's a little bit like going to court or junior court. I'm not sure exactly how to describe it, but either government agencies or the property owners can request an advisory opinion. Each side has the chance to give their facts, and it can be done fairly informally without an attorney or with an attorney. And then we just apply the law as the facts. So the sorts of things we get these requests on, last year, the most common question were on vesting. Utah has a very early vesting statute as compared to other states. Once an applicant has filed a completed application, their rights to the current zoning laws, they vest at that point. 2018, we got a lot of exactions on development questions. That's a really common one. That's one we've seen a lot this year as well. Feel free to ask us those questions. I've got one that I'll be answering already. And then impact fees, 2016, 2015, 2014, a lot of impact fee questions. So feel free to give us calls with those as well. And then the third thing that I'll just very briefly talk about, we mediate eminent domain disputes. So if you're a government agency, you have questions about eminent domain law, if you're a property owner and government agency is acquiring some of your property, you can give us a call. We can answer your questions. I'm of the age, well, yeah, I guess first, eminent domain is the power to acquire private property for public use. I grew up watching Bugs Bunny, so I like this example. The government has planned another freeway for your safety, and the government comes, or the workers come and tell Bugs Bunny that it's the freeway's coming through. And Bugs Bunny is a little scared. At this point, if you're the property owner, give us a call. We can answer your questions. We can offer to mediate. If you're the government agency, you want to call us before you get to this point if you have questions. We can talk to you, but point you in the right direction of what the law is and the like. But, and with Bugs Bunny, he handles things a little bit differently than we would. And he's able to compromise with the city, and the freeway goes around. In the United States, this isn't the way things get resolved. The freeway would be straight, but we can help mediate the dispute and get things resolved as quickly as possible, or without needing to go to court if possible. And a lot of it just is answering people's questions. So we can mediate the eminent domain dispute. We can create a forum and provide a forum for that conversation. We can answer questions about the law and the process. And we also, by law, we can get a second appraisal if compensation really is at question, and a second appraisal would help resolve the dispute. So I'll stop going over that now, and let's jump into today's questions.
Excellent. Thanks, Marcy. We appreciate that. And we do have a queue here of questions, so I'll start at you. So that's great. And everyone take a sip of water and let's dig in. The first one I got was from Heidi. And Heidi wants to know where she can find a nexus study criteria in order to enact municipal fees. Anyone want to chime in on that one?
So this is, and this is kind of the challenge maybe of doing this. Usually we like to ask some clarifying questions and get some more context. But essentially, if I understand the question right, she's asking when the city is implementing municipal fees, essentially what the law says is that they can only charge fees for services provided. They can't use it as a revenue source. And I'm assuming we're talking about those types of fees for applications and things like that, as opposed to impact fees. So yeah, with municipal fees, they can only charge for services provided. And this is becoming an increasingly interesting area, because cities are trying to find new and helpful ways to basically fund operations, right? As far as finding the study for how the fees only offset costs as opposed to provide the city some sort of a revenue, you're going to need to go to the local government who's imposing the fee, and they're going to have whatever studies they have that they used to show what they're showing and why they're charging what they're charging. State law does require that if you do have a question about a fee, then the city does need to have a process set up for you to, number one, get more information about the fee. So they need to provide you the information and the studies that they use and the justification for the fees. And then they need a process for you to appeal that fee as well. But as far as who would have all that information, you're not going to really find a clearinghouse. It's just going to be a matter of going to that local government and asking them for that information, if that's responsive to the question.
All right, we will
Hey, Meg,
follow up with, oh, yep, go ahead, Marcy.
Yeah, we actually, since we solicited some questions ahead of time, why don't I go ahead and I'll answer, we can go through those and then I can stop sharing my screen.
Okay, because I do have 4 or 5 ready for you when you're ready, if you want.
We'll answer the ones we got ahead of time and then I'll stop sharing my screen and we'll go straight to those. But
Excellent.
Thank you everyone. Thank you everyone for, we're just postponing your answer. Please keep asking your questions. Yeah, I just on the Utah APA listserv, we sent out a sort of open ask the ombudsman, and these are the questions we got there. The first one is on exactions, which is a pretty common question for us. This one says, thanks for the opportunity to submit questions. Occasionally we'll have a proposed rural development on a parcel with limited access that doesn't meet our adopted road standards. For example, there's only a 30-foot right-of-way and the developer is proposing a 4-lot subdivision, which requires a 60-foot right-of-way based on our adopted standards. Can we require the developer to acquire the additional right-of-way to access their property? Thanks. This is a pretty common question. So this is a question of an exaction, a development exaction, which is a government mandated contribution of property imposed as a condition of development approval. So that can be either the land, so the contribution of the right-of-way itself, or it can be the improvements themselves, the road, the curb, the gutter, the sidewalks, maybe other flood control measures. And it's lawful to require the dedication of land if it's offsetting the impact of the actual development itself. So just like Jordan was just talking about with fees and the like, there has to be a connection between what the impact of the development will be and what's being asked. So the legal standard, and this is in Utah Code 10-9A 508. A municipality may, well, this is for cities. The counties have an identical standard in the county LUDMA. But a municipality may impose an exaction on development proposed in a land use application if there's an essential link that exists between a legitimate government interest and exaction, and each exaction is roughly proportionate, both in nature and extent, to the impact of the proposed development. And a lot of people say, wow, I mean, thanks, but that is basically meaningless to me. It looks like it's written by an attorney. And sort of as a rule of thumb, sort of as a common practice, many municipalities require the dedication and construction of the half width of a road along the frontage of a property. So that's just common practice. It's generally accepted as being roughly proportionate to the typical road impacts. Now you'll note that standard corner lots are going to have a greater impact than non-corner lots, and that sometimes it might not be appropriate. It might be, you know, a 2-mile road that only one home is being proposed on, and that doesn't seem to balance. So, but that's sort of a rule of thumb to use. Jordan, I'll let you answer this next one. It's the roads by use question that we got ahead of time.
Yeah, so I'll read that one real quick. It may be good, especially for rural planners, to have an answer to the question of when an existing road is considered a public access road as opposed to a private road. How often does a property owner have to block a road to keep it from becoming public? This is a big issue in counties where property owners often try to block existing roads that have no recorded easement or right-of-way, but have been used by the public for decades. So this is a great question. This is one we get a lot related to roads by use. And I put this up here. I'm hearing a collective groan behind all the mute buttons. Why did you put so much text on the screen, Jordan? What are you doing?
Well, we are attorneys, right?
The part of the reason I did it was just to show that, hey, the statute on roads by use is pretty short. So if you're interested, and it might be worth it to look over and read. But also a good thing about this statute is it's a lot more clear than it has been recently. And that's a good thing. So as far as when a road is private or public, you know, I assume the question is talking about in the road by use context. So, you know, under the public use constituting dedication statute, you see up there, I highlighted a highway is dedicated and abandoned to the use of the public. In other words, it becomes a public road when it's been continuously used as a public thoroughfare for a period of 10 years or more. So there are a lot of roads out there where it's clear to everyone that this is the case, right? It's a public road, the public's been using it for 10 or more years. Everyone's on the same page, right? But there are cases where there's disagreement, right? And so if there is disagreement, this is what one or either side is going to need to show evidence or a lack of evidence about, right? That either, you know, the public has been using it as a thoroughfare for 10 or more years, or for some reason or the other, they are not, right? And to the blocking question, so let's say that someone starts using your land as a thoroughfare, the public does, and but they haven't been doing it for 10 years yet. Property owners can protect themselves, and they actually have an affirmative duty to do so if they don't want it to become a public road. And I've outlined and highlighted how they can do that. And this is the section that just this past legislative session was kind of essentially reverted back to the old rule and a more workable rule. For a while there, it was actually really hard for a property owner theoretically to be able to protect their property if the local government, if the highway authority didn't want them to. But now, as you see there, all they really have to do is they have to let the highway authority know, whether that's UDOT or the county or a city, 72 hours in advance that they're gonna interrupt the public use, and then they got to do something, right? They got to block it off. They got to put up signs. They got to do something that's reasonably calculated to interrupt the established pattern and frequency of public use for no less than 24 hours. And then as soon as they do that, that resets and restarts the 10-year clock. So that's how a property owner ensures that if someone is using their property to access recreational land or otherwise, whatever it may be, that it doesn't become a public road. And for those that have been used for years and years and years, essentially there's two ways. Well, so what the law says is once the 10 years has elapsed, it does become a public road, right? And the public has an easement over that property to use it as a public road, and it doesn't go away until the government formally vacates or abandons it. But if there's a dispute, right, if the property owner disputes that it's been used by the public or that it's a thoroughfare or that 10 years has lapsed, really the only other forum you have to resolve the question is for one or the other party to go file a lawsuit, and to have the judge resolve the question. So there's that one.
Thanks.
Marcy, we have a question back on your last slide.
Sure.
Clarification. So I'm just going to read it out to you. It's from Steve. And he's asking, similar to the example you brought up, if a project is being developed along a major roadway, but either isn't using the roadway for access or only uses a portion of it for access, can the city, county require the developer to dedicate and improve any of the right-of-way improvement? If not, can they require the developer to dedicate and improve any of the right-of-way improvements?
Good question. And really, there's the correct answer is there needs to be a mathematical calculation of what the impact on development is. So certainly, just off the top of my head, if a single family home was going in on a 10-acre lot adjacent to I-15, but didn't access I-15, I wouldn't think that the impact of development of the single family home would warrant the expense of building, you know, a mile or so of I-15. So it's really the municipal government needs to do a road study to say this is how much it costs, this is what the impact on the development will be, and this is the value of the land or the improvements that we're charging. The reality is that most municipalities aren't set up to do that sort of calculation. So that's where sort of the common answer, the rule of thumb comes in. But as you really dig into more of the details, it's really up to the municipal government to make that justification. I mean, Jordan, do you have something to add on that one?
Yeah, and I mean, yeah, it is. I think that's the key, Marcy, right? Is that it's the local government has the burden of showing that they're experiencing an impact that the developer needs to offset because of their development, right? And it does get difficult when you're talking about adjacent roads without access. It becomes a matter of providing good evidence or not requiring it if you can't show that the impact of the development necessitates or warrants the developer constructing that improvement. The rule is and the standard is that you don't require individuals to pay for impacts beyond their own. And so it's important that a local government be able to show that the impact of the development is necessitating whatever exaction the local government is requiring, for sure.
Excellent. We have a follow-up on that too, Marcy, and more questions on that after you're ready.
Well, just I'll just say real fast, we get a lot of advisory opinions on this. And so people can go to our website and access past advisory opinions on exactions, or give us a call, we can send them to you. And you can kind of see where we've drawn the line by applying the law to past facts. It's a very inexact science though. But yeah, you had a follow-up question on this one. Go ahead.
Meg, are you there?
Yep. Did we lose you guys for a minute?
You froze for me just for a second.
Okay, I'm here.
You said you had a follow-up question on exactions?
Yes, I did. Yeah, from Roger. And he's saying that he feels that question number one, this one on exactions, wasn't answered about whether the government can require a developer to acquire a right-of-way from another property owner. And it's Roger that the answer must be no for reasons other than exactions law, but because the, just trying to pull in here. Oh. Sorry, it has to be for reasons other than the exactions law, because the developer may need to adjust the site design to accommodate the necessary right-of-way on the developer's land. Or the government can condemn additional right-of-way, which is often not practical.
Yeah, I mean, I guess you're right that the original question talks about, it would sound like buying 30 feet of right-of-way from an adjacent property owner in order to provide the full 60 feet. And I guess without more facts, I wasn't able to envision how that would work, or the scenario where that would be involved. The cities can require that certain access be provided. It sounds like I would need more detail.
Yeah, thanks for the perspective, Roger. That's good. So
agreed. Thanks.
Okay.
Well, I'm going to jump ahead. Yeah, unless you have more exaction questions.
Nope, that was it on exactions. I'll let you get through your list, and then we've got a list piling up.
Great. So I've got one more question, boundary by acquiescence. This comes up a lot. The question is, good morning. Thank you for your inquiry. Our planning division has a question about boundary by acquiescence and how it applies to Utah law. See the attached article. And they linked to this article by boundary by acquiescence from Kessler Rust. And Utah, boundary by acquiescence in Utah, basically it means that if a visible line marked by a monument, a fence, or a building, usually it's a fence, but it could be, say, the side of a garage or a canal, something like that. But if both sides of a visible monument, or like the fence, are occupied by the neighboring property owners, and that both property owners act as though that's the boundary. So on your side, you paint the garage if that's the case, or you put sprinklers in on your side, or you install landscaping, or you weed, or you put Roundup up on your side for a period of 20 years, then the boundary itself actually shifts to where that monument is. Now there's certain things that could make it not shift, like if one property owner is given them permission, sort of a license to put the fence somewhere other than the boundary line, then it wouldn't shift. But otherwise, if there's been occupation up to a visible line for a period of 20 years, and it's property owners on both sides are acting like it's their property, then the boundary actually shifts. We get a lot of questions. I mean, it shifts automatically legally, but it doesn't become of record unless property owners sign a boundary line agreement and then record it. And if they might not agree, they would need to go to a judge and file a quiet title action and have a judge make a formal decision that would be of record. Jordan, do you have anything to add on that one?
No, thanks. That was good.
And I'll let you answer the last question we got ahead of time, and I'll stop sharing our screen and we can take questions that you have piling up, Meg.
Okay, yeah, so this one, and this is a good question that we get often. Why in state code can someone who has a deed go and record it to break up property and essentially subdivide? But then in the subdivision section of state code, it says you do that and you're creating an illegal parcel. We've had very angry people call us and not understand that one thing is legal to do, but create something illegal after it's done. I hope this question makes sense. And yeah, it does. And I appreciate the question. And I think often, so what this is referring to, as I understand it, is essentially anyone can go and hire a surveyor to divide up their property into meets and bounds descriptions, and then go and record those parcels at the county, and the county recorder has an obligation to allow those parcels to be created. Often what you hear is those parcels, if the property owner subsequently wants to develop them, they're referred to as illegal lots. And I've actually kind of evolved to use the term lots that were created without going through the formal subdivision process, just because the term illegal lot sometimes puts people off, right? What do you mean my lot's illegal? I did everything legally. I hired the right people. I did the right things. It's a legal lot, right? But what it is it's a lot that cannot be developed, right? A municipality, and I think Meg just posted to the chat, can withhold a building permit, right? Unless the lot was created through the appropriate subdivision process. And there's good reasons for that. I mean, the modern subdivision process was created to ensure that lots are developable, that they have services, that they have adequate access, different things like that. And so, you know, when I talk to property owners who have these kinds of questions, what I'll let them know is, hey, you're absolutely right. The lot that you own it's a legal parcel, right? I mean, you can buy and sell it, people can own it, but you need to also realize that municipalities have the authority to determine when a lot is eligible for a building permit. And to become eligible for a building permit, you need to subdivide land according to their local subdivision ordinances to ensure that it meets the requirements for further development. So that's often how I'll try to frame that question to help people understand the difference and how they can make their lots developable and usable further. So Meg, what do you got?
Okay, so I've been keeping all your notes. So what I'm going to do though is instead of starting back with the first one we got a few minutes ago, I'm just going to stick on this idea of subdivisions and bring you the questions on that while we're on it. And the first we've got here is, can you explain the difference between lot line adjustments versus boundary adjustments in the code? And these terms are often used interchangeably, and the state code isn't clear to me how they are different or treated differently. And then Paul, maybe you can clarify your ask, does this apply to publicly owned property? I'm not sure if that relates to that. And then the other question was, and I know Sean's on the line and he helped us do the subdivision code last year, so he could maybe jump in on that differentiation. But we had a second follow-up question about, can a boundary acquisition by occupying, and I'm not sure I understand this, can a boundary acquisition by occupying it occur, but it violates zoning codes? Can it become the legal property line of record?
Well, that's a lot of good. So let's start with one at a time, right?
Dive into that.
So the first one was the difference between a boundary I'm guessing what he's asking is what's the difference between a lot line adjustment and a parcel boundary adjustment in the code?
Yeah.
And so just to commiserate with you a little bit on that one, I have a document on my hard drive that's called parcel or boundary line gobbledygook is what I called it, right? Because state code has been kind of contradictory and unclear about, for instance, when a local government has authority to review someone moving their boundary line, right? I think we tried to clean that up a little bit the past session or two, to the point where you have, okay, a parcel, what are the two terms? Parcel boundary adjustment and a boundary line agreement. I think the important distinction to make and how I explain it to myself is, if you have a lot line that you're adjusting that involves a lot in a recorded subdivision, then you need to prepare an amended plat to adjust that line. So you have to hire someone to go prepare a plat showing that line is going to be adjusted or moved. But if that's all you're doing, then you really don't have to, it's not subject to certain requirements like the noticing requirements and planning commission review and local government review. I think it's clear in state code now that none of these can be reviewed by the local government authority. That doesn't mean property owners probably shouldn't go to the local government to say, hey, if I make this adjustment, is it going to make my lot undevelopable in some way? But whether it's a parcel boundary adjustment or a lot line adjustment, I think it's clear now that neither one may be reviewed by the local government, right? The parcel boundary adjustment, similarly, you can go and you can execute quitclaim deeds. And when we're talking about parcels, I refer to those as land that is described not by a subdivision or in a recorded plat, but is just described by meets and bounds descriptions, right? And for those, if you're moving a boundary line, again, it's not subject to local review. And additionally, you don't have to do a plat because you don't have to do an amended plat because there's no plat to amend, right? So you can go and execute those by quitclaim deeds or however you want to do it. Hopefully that's helpful. Anything you'd add, Marcy?
Well, I just was going to jump in to add about the last question. If bounded by acquiescence, what happens if you're, say, in a subdivision or in a zone that the minimum lot size is 10,000 square feet, but the fence was built, failed to be built along the property line? Let's say it's 10 feet into one of the neighbor's property and the boundary shifts. Could it shift even though the one lot would now be too small, would be smaller than what is permitted in the zone? And the answer is yes. That boundary shifts regardless of what the zoning law is. The property owners would then need, they could come up to some resolution to push the boundary back, or they could ask for a variance of the city, but bounded by acquiescence, that shift of the boundary, that occurs regardless of what the zoning is.
Yeah, and that's a tough issue. I tried to do some research on that to see how you can resolve that, and I wasn't able to really find anything where Utah courts have addressed that matter, right? I mean, if a boundary by acquiescence occurs and it creates a substandard lot, does the property owner have any rights moving forward? It's a tough issue, and we do try to encourage local governments to figure out ways to be helpful to property owners who might find themselves in situations like that. So.
And on the boundary by acquiescence, Paul had a question about whether that refers to or applies to public property.
Oh,
that's a good question. So our understanding is that you cannot adverse the sovereign, meaning that a private property owner building their property, their fence line, say in the wrong spot, could not, after 20 years, acquire property that was publicly owned, it was owned by the government. I'm not sure about the going the other way. I think it could. Jordan, you want to jump in there?
As far as as far as a public entity,
yeah,
getting a boundary by acquiescence against a private party.
Mhm.
I mean, that's a taking, right?
But if it'd been 20 years,
yeah, so I mean, if certain statutes of limitation pass, or if it's like a road by use, so there could definitely be exceptions, right? Or things that would preclude the property owner from bringing a claim. But I think it would be more probably addressed in the realm of the context of a taking as opposed to a boundary by acquiescence. And yeah, but and to further Marcy's point on adversing the sovereign, there is an interesting line, I think, in state code that indicates you can't you know, get prescriptive rights or acquiescence rights in public property that is put to a public use. So there may be an argument out there that if the government is just holding something, but they're not actually putting it to any sort of a public use, that boundary by acquiescence may be able to apply. But I've never seen anything super definitive, so I wouldn't rely on that. But it is out there and something to keep in mind and consider when you're running into these issues. So.
Okay, 2 more questions on this rabbit hole of lot lines, boundary adjustments, everything else. But I just want to encourage people, please use the chat box and not the Q&A because we're trying to follow one thread and not the other. We will get to the Q&A, but if you could use the chat box, that's much appreciated. So following up, Jordan and Marcy, if a parcel is created by meets and bounds but does not comply with lot size requirement, can we deny a building permit and require the owner to bring it up to the lot size requirements? And then I have another follow-up on that as well.
I mean, the short answer is yes. Yeah, if they haven't gone through the subdivision process and they don't meet any of the exceptions for not having to subdivide, then yes, the local government may withhold. And this can be a really hairy issue at times as well. I know local governments has tried to deal with this, and we encourage local governments to create a path forward for a property owner, especially if, well, primarily if they're a subsequent purchaser, right? So let's say someone divided up lots and then they sold them all off and represented to the buyer, the sellers, or to the buyers, that these lots were developable, and then someone brings that in, brings a permit application in to say, hey, I want to build my dream home here. And they find out that, hey, this lot was not created through the formal subdivision process. It puts that property owner in a really difficult situation because, yeah, they probably could go back against the seller for different things. But at the same time, you know, we think that it is within the local government's authority to provide a path forward to legalize those lots, even if but it is a tough issue. So, but yeah, the short answer to the question is if they haven't gone through the formal subdivision process, and they're not an exception to the subdivision requirements, then you can withhold a building permit until they bring their lot to development standards. So.
Okay, and then more on subdivisions. So if they are in the plat, the lot line adjustment, this is from Mike, if they're in the plat, the lot line adjustment rules don't apply and they must do an amended plat. If they are lots of record or unsubdivided parcels, then the lot line adjustments apply. Is that correct?
I'd want to ask a few clarifying questions, but essentially, I think with both scenarios, you can use a boundary line agreement, right, to resolve the issue. Just understanding that if the lot is in a subdivision, then you also do have to go record an amended plat to show the change. I don't know if that answers the question or not.
We'll see. I'm sure they'll follow up. And then can a local ordinance require a subdivision amendment to be approved by the Planning Commission when adjusting lot lines between subdivided lots?
I don't believe so.
So I want to go look at the state statute, but I can't do that in a way that is convenient right now.
That was one of the recent changes. Here, let's see. I do have my computer here, but yes, yeah. I believe one of the standards is that it's not subject to Planning Commission review.
Well, we can, and you're not sharing the screen anymore, so you can feel free to post. But I'll skip to the next one while you guys think about that. And this is from Roger again. state law addresses legal non-conforming uses and legal non-conforming structures, actually non-complying structures. Do you see the need for the state to address legal non-conforming lots? And he says, hint, hint.
Say that one more time if you could.
Okay. So state law addresses the, the non-complying and non-conforming structures and uses in the state code. Do you see the need for the state to address legal non-conforming lots as well? Which I think they do, but that's the question.
Yeah, I would agree with that. I mean, so I've worked in the past as a planner, and I mean, we kind of had our own processes, right, for what you do with a substandard lot. In the local government I worked in, we said, yeah, you can develop on that. If it's a lot of record, you just got to follow all the same setback requirements and everything. So I think in practice, local governments are dealing with it, but I share, was it Roger?
Yeah.
I share his frustration in that it's really not addressed in state code. And if it were brought to the question legally, I think people would have to scramble to find definitive answers for sure about if that's appropriate or not.
Yeah, I'll add, I'm not sure that there's going to be a one-size-fits-all answer that the state could provide, because there are legal non-conforming, I mean, it sort of depends on what are you calling a legal non-conforming lot.
Yeah, that's a good point.
And I wouldn't want to pull the discretion from municipal government to be making the decisions for what's right. For instance, if an area was rezoned where now the minimum lot size was, say, 2 acres when lots had been carved out to 1, that really seems like a political solution, not a state law decision, but sort of a local issue. Or I also can imagine, I mean, there's some lots that are sort of small by 10%, or they're the right size, but sort of slightly awkward in shape because they're a leftover parcel or something, and they were created 100 years ago on accident. I see that as fundamentally different than someone who comes in and subdivides under and gets things recorded, knowing that they're creating illegal lots and selling them off. There's just such a variety of conditions that can create a non-complying lot.
Excellent.
It's a good question for discussion, though.
Yeah, so and I'll follow up. So 57-1-45 refers to boundary line agreements, and I think you'll find that whether it's a subdivision plat or amendment, like lots in a subdivision, or a parcel boundary adjustment, they're both going to point to this provision as saying you can do it this way, right? And that's where it kind of details out that, hey, you need to do an amended plat. So if there is a plat, then you need to amend the plat, right? But if there's not, then you don't, essentially. And down at the bottom there, it does say that a boundary line agreement, notwithstanding the subdivision provision in LUDMA, is not subject to public notice, public hearing, or preliminary platting requirements, the local entity's planning commission review or recommendation, or an engineering review or approval of the local entity. Again, that's not to say, and I tell property owners, I'd probably go in though and just show it to them, right? And make sure that you're creating a situation that is going to be eligible for a permit, but that is in state law that they are exempt from those requirements. So.
Excellent. All right, Mike, Drew, Jill, Paul, we'll get to your questions now. Well, hopefully we'll have some deviation from them, but we'll start back with Mike, who asked about special exceptions, wondering if they were allowed in the state code, which came out a few years ago. But what are some of the best practices regarding this type of use? In e.g. having standards and qualifications, and if our codes, this I think is more of a comment than question, if our codes are supposed to be plain language, why isn't the state code to the same standard? And then
it is.
When I was yeah, when I was chatting with him,
even
again,
if sometimes it look like it's not, right?
He asked a follow-up. Are you he's saying are they, should they have are ones that are arbitrary with no set standards, the ones that they were looking at taking out of the code. What is the alternative if they're not allowed? And so I'll let you guys take that, and thanks.
So Meg, I'm going to ask you then, give me some context when you say special exceptions were addressed a little while ago.
So probably 7 or 8 years ago, before there was a term for special exceptions, and it was removed from the state statute in order to move to this more objective application of review, whether it's either permitted with criteria or whether it's directly to a variance. We were having the unfortunate situation of having kind of oddball special exceptions that smelled like variances but weren't treated as variances, and then some that just already maybe had a set of standards, so they were kind of permitted with standards, if that makes any sense. So it was an attempt to clean that up, and so I think that's where we're at now.
That's good. And part of the reason I ask is some states use the term special exception to refer to a conditional use, right? And so in that regard, if that's what we're talking about, then, and this, the person who's asking the question is coming from a different state, then yeah, we do allow conditional uses, but it's under the criteria established in state law where, they're approved. And as long as you can mitigate detrimental impacts, they cannot be denied, right? According to reasonable and objective standards in the local ordinance. So yeah, and then was there more to the question?
So Mike, if you want to pipe in, but basically what it means is we are moving to having that criteria. And let me make an example of permitted with standards, what I mean by that. So in codes, we have home occupations and we make those conditional use. Really, we have all the standards for those home occupations already listed. So it should be permitted if you meet those standards in your code. So I think you're headed down the right avenue that, you want to have standards more when you are having, I want to call them exceptions, but when you have a use that you want additional criteria on, put those standards down and have those codified.
Perfect. No, yeah, that's definitely best practice for sure. Thank you.
Okay.
And I'll just jump in that, so we get calls from all sorts of folks in all sorts of situations on both sides of the fence. And lots of times we get asked, why is this? And I believe it protects the property owner and it protects the neighbors, because it means that there are rules that the cities need to apply. So new development that's coming in is going to need to meet a set standard that was thought of ahead of time, that it can't be sort of arbitrary. It can't be, make it up as you go. So private property owners and who are looking to develop and their neighbors, they have some certainty. They can look to the code and see what can I do with my property? What can my neighbor do with their property? Instead of really being left to the whims of the politicians. And then the politicians aren't being pushed to make decisions that maybe aren't in the best interest of the town or haven't been thought through in the bigger picture.
Excellent. All right, Drew, we're going to get to your question about, he has some constituents that are being prohibited by Dominion Energy from building, planting, or putting a trampoline on their easements. And there's a recent appeals court case dealing with Dominion and allowed encroachments on their easements. Do you know any status on that issue?
It's a great one. And yeah, so the recent court opinions on the matter involved, what was the entity? It wasn't Dominion, it was a canal company here in Salt Lake. They run water from Deer Creek up into Salt Lake County. I can't think of it right now. But yeah, so what that said is basically this canal operator, they had some property, their canal ran through a kind of a kaleidoscope of different interests, right? In some places they owned in fee title the property that the canal goes through. And in other places they just had an easement. And basically what the court opinion looked at and said was, hey, thank you, Steve, Central Utah Water Conservancy District. yeah, so it involved them, and basically they were acting in many regards over these properties that they had easements on as a land use authority. They were imposing zoning like requirements, setback requirements. You can't put landscaping on it requirements, those types of things. And what the court said is, hey, Central Utah Water Conservancy District, in these places where you hold an easement, you are not a land use authority, right? You are an easement holder. And so you're treated like any other easement holder in that you can't unreasonably interfere with the interests of the underlying landowner. And similarly, the underlying landowner can't unreasonably interfere with your interests, right? So to the extent that a property owner was going to do something that prevented them from conveying the water and maintaining the pipe, they couldn't do those kinds of things. But to go so far as to, you know, impose additional requirements beyond that base relationship. Now, if you have a recorded easement, that's different, right? If you have a recorded easement that sets forth standards and says, hey, you can and cannot do this, that's going to, but absent that, if you just have a general grant of authority or general grant of easement, then it defaults to that general rule of neither can unreasonably interfere with each other's interest. And so if the property owner wants to, you know, put flat work or, you know, landscaping, there's a good chance that they might not be able to be compensated if that needs to be torn up for maintenance or something like that. But at the same time, that easement holder, and so in this case, for instance, getting to the question, right, if Dominion Energy has a general easement and they're saying you can't do things that their easement doesn't allow them to say the person can't do, then they've probably overstepped their authority and may be trying to act like a land use authority in a way that they don't have the ability to do. So based on that recent case law.
Great. And then just to circle back to the exceptions question, I just wanted to clarify, can you create an exception to street improvement requirements if they meet certain criteria in the code to qualify for the exception?
Absolutely, you can do that. If it's in your code, you're doing exactly what you should be doing. You're creating, you're laying out what folks need to do, and letting them know ahead of time and applying the written down standards to their development. So absolutely, yes.
Yeah, and that was part of the reason I asked the clarifying question on special exception, because, you know, you can, yeah, so, you know, landscaping standards, other development standards, if you want to introduce flexibility into your code, you can do that, but you can't do it in an arbitrary way, right? You do have to provide standards that the decision maker has to follow, and they need to be as objective as possible standards, right? That everyone could turn to be able to look and say, okay, yeah, if we apply these standards, we're going to get consistent results to allow some built-in flexibility in the codes. So
great. And Paul and Matt, we'll get to you. My next one is from Jill, and Jill asks on the zoning and subdivision standards and ordinances during a public meeting regarding an application. Is that the time to go against or change your ordinance, or just for certain situations, even if it is not in standards or your ordinance?
That's a good question. So this goes back to giving people notice and certainty, and what I mentioned at the very beginning about Utah is a very early vesting statute. So in Utah, once someone has submitted a completed application and paid any related fees, the city is obligated, or the county is obligated, to apply the laws then in effect to the development. So it might be that someone comes in with an application for a use that you realize later, wait, I'd rather not have that be there, or that lot is really smaller than what I would like, or the sidewalk should be wider, or the cul-de-sac should be narrower, whatever it is. You might want to change it, but you change your ordinance, but it wouldn't apply to the application before you. Any proposed changes would need to be proposed ahead of time. And there are some exceptions for moratorium with temporary land use ordinances, such as more commonly called moratoriums, but you can't change the rules on people on the fly.
yeah, and this goes back to the age-old administrative legislative distinction, right? So the city council, they can consider public input, they can consider preferences, when they're making the law, when they're legislating, right? But once those laws are in place and you have an application, an administrative application before you for site plan approval, subdivision approval, things where you're taking the law, that the ordinances that are in place, and you're applying them to the application as proposed, you have to follow the ordinances there, and you can't change the rules midstream at that point.
So I see Jill's asking a follow-up question. For example, if they have certain standards, but the applicant does not want to abide by it, can you change it? So the city wants to, say, lessen the standard in order to appease the applicant, that would be permitted.
Okay, then we're going to go back up to Paul, and this relates to subdivisions, and he was looking for a citation, but this was in regard to a comment that you had made about, and I'm just trying to find it here. Here we go. Can we get a code reference that you, please, in regards to legislation that you mentioned that allowed developers to get building permits prior to paving streets?
I need to find that one, but it's actually that state law. Yes, or Jordan, you might know that one. Jordan's good.
Not off the top of my head. I'd have to go digging a little bit.
Let me dig, and if I can't find it in time, send me an email and I'll email you the response.
Is that Paul Allred? We can reach out to him. We can send him an email.
It's Paul Lawson, and I believe I think it's 0988022D. So if you want to look that up while we're going on to another question, and I posted that in the chat to you guys panelists.
Thanks, Meg. Meg's going to join us in the ombudsman's office.
I know.
No.
We just need to find you an office.
Just been doing this too long. The next question we have, and I'm going to try to go back up. I think this is going to, let's go to Matt's question, and then I'll find.
You know what? I'm going to share my screen real fast because I found it. So Here we go.
Excellent.
But it's not going to the right one. Nothing like doing that with everyone here.
Well,
is that working now, or is this not working?
It's not. Yeah.
I'll just read it to you then. I'm not sure why. Is that it now?
Yeah,
it shows you highlighted their local jurisdictions under the fire code.
That's it. Yeah, that's what we want there. So 15A 5205.6.
Okay, so that's the fire codes issued years ago.
You're good. Yeah, local jurisdictions. If an improved completion assurance has been posted in accordance with section 10A, 109A 604.5, a local jurisdiction may not require permanent roads or asphalt or concrete on temporary roads before final approval of the structure served by the road.
Right.
So they have to bring it up to standards for emergency access, right? But beyond that, they can wait. So.
Right, and we dealt with that in the land use task force a few years ago, Paul, if you remember back, but I guess that will help you on that one. So the next one we'll go to is from Matt, and Matt wants to know, if a city council uses their legislative authority on what is otherwise a black and white administrative land use decision, what are the consequences if a petitioner files a claim?
They'll lose in court, I think is the short answer. Yeah, I mean, and that's the important. There's a really good video out there that Brent, the former ombudsman in the office, did on hats, right? Which hat do you wear? And if you're going to designate your city council as a land use authority, you need to help them understand very clearly what hat they're wearing when they make any given decision, right? So if they're making an administrative decision, but they're wearing their legislative hat and doing so and asking, do we want this here? Do we think it's right? And the code clearly says yes to those questions, then they are opening themselves up to significant liability and risk by doing that. So.
Excellent. And we have about 10 more minutes left, a few more questions to go here. This is from David. Under what conditions can a conditional use permit be amended?
Oh, That's a good one. Usually it's going to be, I think you're going to be turning to your local ordinance for that. State law doesn't really address it. I mean, there's definitely going to need to be a change in circumstances, right? And an additional impact if you are going to require amendments. And I would even say usually you're going to have to show that they're somehow violating some reasonable condition that's already imposed to be able to revisit a conditional use permit. If they've complied with the conditions, they're still complying with the conditions, they've always complied with the conditions, I don't think there's going to be much of a warrant for changing things.
So Jordan, I've gotten asked recently whether or not a city could issue a temporary conditional use permit or one that needed to be renewed, say every 2 years or every 5 years. From what you're saying, it sounds like that wouldn't be allowed.
I think it's a questionable practice. And if anyone has any other thoughts or ideas, I'd love to hear them. I don't think that's necessary. I think if you talk about best practices, it's not a good idea to put sunset dates or annual reviews on conditional use permits. That's not to say I haven't worked in local jurisdictions where they happen and everyone's fine with them. But I don't know, I've never seen any legal basis for doing that, to be honest with you.
That was my take too.
And then on conditional uses, another one from Jill, if the ordinance is on commercial conditional uses, stated it has to be approved by the city, but would be required is not spelled out, can you hold the conditional use until it is approved?
I didn't get that whole question. Did you hear it?
Yeah, if the ordinance on commercial conditional uses just stated it has to be approved by the city, but what would be required is not spelled out, can you hold the conditional use until it is approved?
No, you got to approve it. If it's a conditional use and there are no standards to guide what kind of conditions you're putting on it, then it's a permitted use.
Yeah, I feel like people like to treat permitted uses as a yes and not permitted uses as a no and conditional uses as a maybe. And I view conditional uses as a yes, as long as certain criteria can be met. And the criteria has to be spelled out ahead of time. You can't decide afterwards.
Exactly, that's right. And yeah, so I mean, if you have an ordinance that's written in a way where it says, hey, this is a conditional use, but you start digging through the code and it doesn't identify any standards for imposing conditions, then you're going to need to treat that conditional use as a permitted use, I think is the short answer. And then bring it up to your city council that you need to get that fixed in your code.
All right, we've got another one here. What advice do you both have for cities when using development agreements for infill zoning? What are the pitfalls and what should we watch for? And should the terms be highly specific or more general?
I'm gonna let you take this one, Jordan, but I know this is one we've talked about in our office recently. It can be sort of there's some difficulties there.
Yeah, and I think, so in an ideal world, right, you'd have an enabling statute in state law, and that's something that Utah doesn't have, is an enabling statute for development agreements. I guess I should say this, LUDMA does allow development agreements, right, as a form of a land use control, but that's all it says, is that it allows them. And I know other states establish a framework within which a development agreement can be used. Utah doesn't have that, so you see a spectrum across the state of how they're used and when they're used, and I'd say sometimes you'll have a development agreement in your hand that was probably administratively created, and sometimes you'll have one that was legislatively created. To answer the question of how would I use a development agreement for infill development, I would probably personally, again, this is just, I'm not your attorney, right? But I think it's smart to treat every development agreement as if it's a legislative decision, and treat it as an ordinance, right? So if someone comes in and wants to do a development agreement, then go through the process of asking all the questions you'd ask as if you were creating a new zone, a new zoning district in your ordinance. and then pass it the same way, right? That's going to be the cleanest way, and everyone will be clear about what its result and what its effect is. That said, I have seen ordinances, right, that say, you know, here's the general criteria for development in this zone. And then it says use a development agreement to work out the details, right? So it's almost an enabling ordinance to allow a development agreement. Arguably, you could do those at the administrative level with staff because you have standards, right, that are guiding staff and putting parameters and a framework on how they can create a development agreement. And if you're comfortable with that approach, then I've seen that work, right? But I think if you want to be really clean with everything, then anytime you do a development agreement, put it through the same process that you'd put as a new zoning district through an ordinance, if that makes sense.
But also be aware that you won't have the same freedom to amend it later, because you'll need the property owner to sign off, plus go through whatever steps to amend. But yeah, I would just caution, don't treat it as though it's run it through administrative approval when really what you need is legislative approval, because you're just opening yourself up to lawsuits. Also, I would sort of caution that only pass things you're really willing to live with, even if the party on the other side changes. That what's in that agreement is what you're going to live with.
Oh, you're on mute, Meg.
Sorry, thanks. We have a follow-up from Matt. Can terms of a development agreement be in contrast with an existing city land use code?
It's for that reason that I say, you know, do it through the legislative process so that it, you know, you've passed it legislatively. That way, you know that the development agreement is the law applicable to that development because it was passed as a law, right? If it was done administratively and it contradicts another ordinance, it's gonna really depend on what the ordinances say. I mean, you're gonna have to get into some legal analysis there to know the answer to that one, I think. So.
Excellent. On that great note, I am going to wrap this up and thank our host guests here, Jordan and Marcy, tremendously. Again, it's Property Rights. Is that what you want to shout out your address one more time, your website address?
Yeah, and I'll say thank you for everyone's patience today. I know that that was a little hectic because we're not in person. And if you do have any follow-up questions or clarifications, or we just didn't get to your question or otherwise, or reach out to us. Propertyrights.utah.gov is how you can find our information. Marcy, do you have that slide you want to put up?
That's what I'm just looking to see if I can't get it shared real quickly. I closed it when I was done.
While she does that, we want to again thank you all for attending. We have more roundtable networking sessions. Tomorrow we have a live session at 1 with Peter Kagamaya about creative cities. So we appreciate you being here, and thanks for taking the time. And Marcy, I think you'll throw that up, or should we?
I'll share my screen now.
Excellent. Again, thank you all very much for your time. We'll put up this last slide and then we will move on to the rest of our day.
Thanks everyone.
For having us.